Keeps track of them. I don't know.
I know, it's not letting me do any of it. Oh, here we go.
Do I log out?
Yeah,
Just sign out?
yes. Okay, that's all I needed. It wouldn't let me. I know. I was just like, never mind, I'm not even gonna have, I was like, Liz already did it. Thank you.
We're good to go.
Yeah. I think everybody's running on time.
Everybody's running on time.
We're
Everyone's
live. Testing, testing. Good morning.
Thank you. Thank you. Yes, me? Yes. Okay. Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning. We're here on S-1-SC-38681 CCA of Tennessee versus New Mexico Taxation and Revenue. Can I have entries of appearance, please?
Good morning, Your Honor, David Little on behalf of the Taxation and Revenue Department. Andrew Simons on behalf of the respondent, Your Honor.
Thank you. Mr. Middle, I note that you have reserved 18 minutes for your argument in chief and 12 minutes for rebuttal.
That's correct.
All right. You can proceed.
Thank you.
I bring something to your attention before I start. This says Justice Vigil and that says Justice Thompson, and I know you guys are different on that.
Oh, we know. Can we give you this?
I don't know if it matters.
I'd like the Justice
I was
Thompson.
gonna say,
It's a promotion.
I finally have a reputation I can live up to.
Now you're upside down. It is. Sorry, I didn't mean to.
Thank you for fixing it.
It goes down on the shelf, thank you. Thank you, Mr. Middle.
Mr. Middle, sorry. I didn't mean to. Okay. Madam Chief Justice, and may it please the court. If the seller of a service like CCA selling prison services wants a tax deduction under Section 7947, it is CCA's burden to show that it accepted a non-taxable transaction certificate in good faith that the buyer, here Torrance County, was actually reselling its prison services. In this case, Torrance County was not reselling the services, and CCA knew that. Hence, this is not a case of good faith. This is a case of bad faith. I would like to emphasize one point here at the start. To accept the certificate in good faith requires the seller to have a state of mind that the buyer is actually reselling the services. It also means it has to have a state of mind of honesty and belief and purpose, and not an intent to defraud or cause an unconscionable advantage over the state. As such, a seller is charged with the duty to inquire as to what the buyer intends to do with the service. But no inquiry was needed here because CCA accepted the NTTC, knowing Torrance County was not reselling its prison services. It knew because it was selling those exact services to the United States Marshals that it was telling the department Torrance County was selling. So what we have here is it was making material misrepresentations to the department, which is the antithesis of good faith. CCA's indifference to the truth is bad faith. I'd be happy to take the court's questions. If not, I'll start with the facts and exchanges between CCA and the department that led to the issuance of the certificate. And then I'll go on to how CCA could not have ever accepted it in good faith. So when CCA first started selling its services in New Mexico, it paid gross receipts tax, and it was supposed to. It was doing it right. In about mid-2012, it hired a tax service firm called Ryan. Ryan's job was to help CCA lower its tax burden, which there's nothing wrong with that. So about 6 months later, CCA and Ryan came up with a plan. If CCA was selling its services to Torrance County, and Torrance County was in turn selling to the U.S. Marshal Service, then it would be a sale for resale, and CCA would be entitled to the deduction. To make it work, however, they needed an NTTC. So in December 2012, Ryan Group starts lobbying the department to issue the certificate. Now, in their lobbying process, it was very important to the department and asked a key question: are you reselling these services? The Ryan Group agent for CCA had signed a TIA, which is a tax information authorization form. So the department can share confidential tax information CCA's with Ryan. So Ryan says, yes, the services are being resold. That was false.
And it was false because CCA was selling directly to
United
the
States
Marshals.
Yes, Justice Bacon, and there's evidence in the file. It was Exhibit E in the Administrative Hearings Office, where the invoice went directly to the United States Marshals with instructions on the invoice to send the wire transfer to CCA. So there was no resale by Torrance County. So
What would have indicated that resale? Is it simply the direct invoice? Is it the direct invoice to CCA that creates this incorrect representation that it was resale?
yes, sir.
Okay.
So the certificate was issued December 12, 2012, 12/12/12, easy to remember. And about 2 years later, the department did an audit. During the audit, it became known to the department that the sale was a direct sale, so we assessed CCA.
Where is the evidence that, so you said it was the auditor that made this misrepresentation?
Sorry.
I mean, that Ryan LLC is the one that made the misrepresentation.
Ryan is CCA's agent, and they're charged with.
I understand that, but is there any evidence in the record that the taxpayer actually knew about this misstatement?
Only through their agent, Ryan.
What does that mean?
So CCA was not, okay, what's involved, what's in the record on page 22 of the DNO is at the Administrative Hearings Office, David Garfinkel testified. He was the CFO of Core Civic, which is now CCA. And he testified that the representation was false. Did he testify? Did we know that at the time in 2012 that it was being issued? Did CCA come to the department and talk to Rebecca Abo? The record shows that no, those communications were between Ryan's agent, employee, Ms. Johnson, and the department.
So it's through the agency that's attributed to taxpayer.
That's correct.
Misrepresentation.
That's correct, and this gets a little bit into the woods. But if there, see, even though they're the agent, though, there's the presumption that the principal knows what the agent is saying.
I understand.
Okay,
I just wonder if there's any actual knowledge from their part.
there's nothing in the record that shows any communications with CCA directly, actually until the hearing in 2018.
Counsel, I have a question. CCA approaches the department in an effort to obtain a certificate on behalf of the county, right? Because the certificate goes to the county, not to CCA.
Correct. What happens is generally that the buyer comes to the department will issue the NTTC to the buyer, Torrance County, and then Torrance County will execute and deliver it to the seller.
But is it correct that this didn't happen here? Here, the seller approached the department.
Yes, Judge Geiswald, that's exactly correct. And it's not really so unusual. Ryan LLC does a lot of business with the department on behalf of other taxpayers. So I don't think that was anything improper, but it's not normally how it's done because it is the buyer that comes to the department.
But any benefits that would come from that would be a benefit to CCA in the sense of not having to pay gross receipts taxes.
Absolutely, that's correct.
Okay.
Okay, and so what it says under the plain meaning of the statute, accepting in good faith conveys a sense of inquiry when it says that the buyer will employ the service transferred in a non-taxable manner. And so that inquiry has to write is a honesty and belief or purpose or an absence of an intent to defraud. It's a subjective standard. It's not even a very high standard, but it still has to raise the level of good faith. And it can be as simple as asking the buyer what they intend to do with it. So for an example, if I run a steel fabrication business and HB Construction comes in and orders 200 tons of steel, I have a pretty good idea that's going to be used in a construction project. But if there's any doubt in what the buyer is going to use it for, that means that the seller has to engage in some inquiry with the buyer till it rises to the level of good faith.
Well, and here, how would inquiry have changed anything, given that, at least according to your client's argument, the invoice was going directly to the Marshal Service, no intermediary, and the payment was going directly to CCA. There's no inquiry even necessary under that scenario.
Which is what's in bold on the top of my page. You're absolutely correct. And that's where the problem with the Court of Appeals decision was, because they said there was absent any evidence. And they couched that absent any evidence of accepting the NTTC, as Judge Eichwald said, from the buyer, but they still didn't have the state of mind when they accepted it, whether it came from the buyer, whether it came from anybody. The statute still requires some sense of honesty and purpose and belief that the buyer will be reselling the services or product. And so that's where it falls apart, because otherwise what you're reading is the statute will be employed and then serviced by the buyer in a non-taxable transaction out of the statute. And you're saying that mere possession of a piece of paper suffices. Well, we all know every word in the statute has meaning and we shouldn't read it out, surplusage. And that's what my colleague on the other side is effectively arguing, is that they had a piece of paper and it was get out of paying tax card for free. And that's what the Court of Appeals held, because it came from the county. And there is no evidence in the record what the county's state of mind or participation during the transaction that led to the issuance of the certificate. It is true the county was not called as a witness.
The Court of Appeals, from the county, but Court of Appeals cites this Rebecca Alba with the department, quote, agrees the taxpayer can accept the NTTC for the receipts derived from housing the inmates from USMS. And then says there's no evidence that's unreasonable to rely on.
Which is absolutely correct, because there's two standards here. There's a standard of the buyer issuing the NTTC, and there's the standard of the seller accepting it. That statement goes to the buyer's issuance. And so it was perfectly reasonable for Torrance County to rely on the issuance. That doesn't excuse the acceptance. There are two different sentences in 7943A. So what the Court of Appeals did was truncated the test by focusing slowly on what the mindset of the buyer was at the time that it was issued.
Regarding good faith.
Regarding good faith.
As opposed to the buyers.
As opposed to,
Or
as
as opposed to the
seller.
sellers.
As opposed to the seller.
Can you talk about the application of McKinley Ambulance?
McKinley Ambulance, it's still the same type of case. McKinley Ambulance, he was providing ambulance services to Indian Health Services, both in-state and out-of-state. If you're providing services out-of-state, they are exempt from taxes. Okay, he accepted an NTTC, and the court said that was not accepted in good faith because he was providing in-state services. And you can't change a taxable transaction into a non-taxable transaction by accepting a certificate. Well, actually, that's an incorrect statement, because if you look at LECO Telecom, there is one situation where you can turn taxable to non-taxable when you accept the certificate in good faith. And that the Court of Appeals below got mostly correct in paragraph 26. In paragraph 26, they said CCA was not entitled to the deduction because it was selling services and not a license. Correct. Then it says in the same sentence, but it was entitled to another deduction. Never explains what that deduction was because it wasn't there. But if CCA had accepted in good faith, they probably would have gotten the deduction. Because again, accepting doesn't mean that you're in good faith, doesn't mean that you're guaranteeing the buyer is reselling. All you have to do is have a subjective state of mind.
And it's the state of mind at the time of
Acceptance.
of acceptance, not
acceptance.
events that come later.
Right, and that's the Article of Materials case where they changed the law, and he said he should be able to rely on what happened, and the court said, no, you have to stay up to speed with tax law.
And we're supposed to look at all of the facts known to the seller at the time, correct?
Known to the seller. And if the seller doesn't have the facts, the seller has to do some form of inquiry. So, and that's what did not happen and didn't need to happen because they knew. So the Court of Appeals was close in paragraph 26 because then once they did, if they had accepted in good faith, we wouldn't be here today. But the problem is there was no inquiry, none necessary, because they knew what was going on. So
Where do you get the duty to inquire?
because the statute 7943A says the seller accepts in good faith
In good faith.
from the buyer that the buyer will employ the services purchased in a non-taxable transaction. So to determine whether it's being involved in a non-taxable transaction requires an inquiry and some investigation.
No, the statute says when a person accepts in good faith a properly executed non-taxable transaction certificate.
So you're reading the 2018 version of the statute, and
Let me read the correct,
this
the
was,
11,
the 2011 is the applicable statute.
that they will employ the property or services.
Correct.
Okay.
Will employ is,
But does that translate into a duty to inquire?
it conveys a sense of inquiry that they are employing. And that language was used by the All-Star Amusement case, that's the Missouri Supreme Court, which was cited by the Simons case as virtually identical to what goes on in New Mexico. So you have this, and again, what I'm saying, it's not, you don't have to be certain, but you do have to do some sort of inquiry.
But going again back to the question of inquiry, whether we write something that requires inquiry or not, here, Torrance County was not making any representations about its non-taxable purpose to CCA because CCA was contracting directly with the Marshal Service.
Justice Bacon, they were making a representation when they handed the NTTC to CCA. It says they're making a representation that they are using this in a resale manner. So they did, when they execute, again, department issues, we send it, in this case, to the county, which would execute it, who delivered it to CCA. When they delivered it, the words on the piece of paper made a representation that they were reselling. So that's
But CCA knew that to be false.
correct.
And Council, follow you up on that, that has to do with ARCO material case, right?
I'm sorry,
What we're talking about was discussed in the ARCO materials case, right?
in the ARCO materials case, see, a lot of these cases get a bad rap and deservedly so. There's 15 or so different types of NTTCs, and sometimes the department says we should have gotten an NTTC type 5, and in ARCOs they gave a type 6, so we rejected the deduction. It tends to be a little, because the representation in the type 6 didn't really change what was in the type 5. The 2018 amendment did away with a lot of that.
No, but I think what the judge is asking you is the scenario we just walked through is like the ARCO case.
Oh, sorry. It's
That's
like the
fair.
ARCO case in the sense that it's still the duty to accept in good faith.
Right.
And ARCOs didn't because if they had read the NTTC, it didn't cover the deduction they're looking for.
And based on the record, I saw several times between 2012 and 2015, CCA did not make sure that the buyer, Torrance County, was abiding by the terms of the certificate.
I'm sorry, I didn't.
No, what I'm saying is based on the ARCO case, the seller has the duty to ensure that what's being sold or whatever transaction comports with the certificate.
Ensure is too strong a word. Ensure raises the level of good faith.
You can answer the question.
So what I'm trying to say is the CCA or any other seller in that respect doesn't have to ensure that the buyer is reselling or using infrastructure or any of the others. That's too high a standard. The standard here is much lower.
Thank you.
Thank you.
Simons.
May it please the court. If I may, I'm going to start by trying to address some of the questions that the court raised with Mr. Middle. And I'm going to start at the back end with ARCO, and I'm glad that case came up right up front, because that case doesn't say that a taxpayer has the duty to monitor its buyer, to make sure that its buyer is using the goods and services in a non-taxable manner. It says the opposite. Okay? In ARCO materials, what happened was the law changed. So the NTTC that the taxpayer originally accepted, that did cover the deduction that the taxpayer wanted to take, no longer covered that deduction because the law changed. So all that court said was, you taxpayer have an obligation to monitor the law, to know if the law has changed. But as to monitoring the buyer's use of the goods and services that give rise to the deduction, the court said, and I quote, "It would create tremendous burden to require a taxpayer to monitor the purchaser's activities." Right? There's no duty to keep track of the buyer. Under ARC
That's
materials.
not what's being asserted is the problem here. It's not that your client is being, by the tax and rev, is not being charged with monitoring the ongoing nature of the transaction. It's that your client knew that
Well-
there was no resale.
I understand the justice's point. I mean, but number one, the department is in fact alleging that CCA had some sort of duty to monitor Torrance County, but I take your point. Let's talk about what CCA knew.
But if they would have monitored, wouldn't have changed the result, wouldn't have changed what they already knew.
Let's talk about what CCA knew and didn't know, okay? Below, the hearing officer found that CCA's agent, Ryan, made one misstatement of fact in one email to Rebecca Abo, who is the chief auditor, right? It was one email with one misstatement of fact, and that misstatement was, the receipts are not coming directly to CCA from the U.S. Marshal Service. That was incorrect. But there's absolutely no support in the record for the notion that that was anything other than an innocent mistake. There's no evidence in the record that Ryan even knew that that was incorrect, let alone CCA.
Well, Ryan's the one that made the misrepresentation, who made the representation.
But there's no evidence they even knew it was a
Well,
misrepresentation.
why are they making a representation they don't know is correct?
I
Is
can't.
that good faith?
No, I can't answer that question. I don't know. My point is there's no support in the record for the notion that Ryan knew it was a misrepresentation. I mean, that's one of CCA's beefs.
So it's a negligent representation as opposed to a misrepresentation?
Possibly, I really don't know enough to say whether it was negligent or not. All I know is that there's nothing in the record to suggest that Ryan, let alone CCA, knew that it was incorrect. And let me also address, while we're talking about it, this idea that, and I think this goes to a question that Justice Thompson asked, sort of at the beginning, like, what's the evidence of a resale, right? I mean, in this case, the department is saying, well, because the receipts were flowing directly to CCA from the U.S. Marshal Service, there couldn't have been a resale. It was a direct sale from CCA to the U.S. Marshal Service. But the department doesn't talk about the fact that there was uncontradicted testimony by CCA's CFO that CCA was only receiving those receipts from the Marshal Service as the payment agent for Torrance County. Okay? Torrance County had a history of paying late to CCA, so CCA said, let us just take the payments directly.
What in the record corroborates that witness's testimony?
Well, there was a contract between, the only contract with the U.S. Marshal Service was between Torrance County and the U.S. Marshal Service. CCA was not a party to that contract. That contract was what obligated the U.S. Marshal Service to make payments, and that contract was with Torrance County, not with CCA. So there's evidence in the record, and by the way, there's nothing in 7947 that says the payments have to flow a certain way, right?
I don't disagree with you.
So the hearing officer obviously didn't find that compelling and ruled against CCA, but that certainly does not equate to CCA must have known it was gaming the system, must have known that this was all a sham to escape gross receipts tax.
What deference do we give the hearing officer?
Well, if he's wrong on the law.
But what you just described to me is a credibility call.
Well,
He didn't buy it. He didn't
No, that's
believe
right,
it.
and
And
that's-
if it's a credibility call, then we're hands off.
right, but he didn't rule. I'm glad you raised that. he did not rule, and this is a huge issue with the department's briefing. He did not rule that Ryan or CCA knew that that misstatement was false. He didn't make a finding to that effect. He didn't draw a conclusion to that effect. And there's nothing in the record to suggest that. That doesn't stop the department from accusing the taxpayer of lying on nearly every page of the department's briefing. If I may get a sip of water.
You may.
So I think it's important to really look at the record and go through it with a fine-tooth comb and sort of determine what does the record say about what CCA and Ryan knew. And going back to your point, Justice Bacon, I'm not suggesting that the hearing officer was wrong on his 7947 ruling. I'm not suggesting there wasn't substantial evidence to support that. All I'm saying is that there's nothing in the record doesn't support the conclusion that CCA must have known that there was no resale. CCA thought there was a resale and presented evidence at the hearing that there was a resale. This hearing officer just didn't agree.
But if the hearing officer didn't agree, ergo didn't believe the witness's testimony, because it could be labeled as self-serving,
Sure.
then what do we as a reviewing court do with that kind of surmise by the hearing officer? If it's based on credibility of the witness, there's not much room for this court.
Well, I think there's plenty of room. I think a ruling by the hearing officer that CCA doesn't qualify for the 7947 deduction, which is not being challenged to this court, is very different from a ruling that CCA doesn't qualify for the 7947 deduction because it must have known that there was no resale and therefore was acting in bad faith. Because that's what the department's arguing. And there's nothing in the record to suggest that the hearing officer found that or concluded that. Okay, now, as far as plenty of room.
Counselor, let me jump in there.
Yeah, sure.
You know, the standard of review on an administrative appeal is whether the hearing officer's decision was arbitrary, capricious, or abuse of discretion. Second, not supported by substantial evidence. Or three, otherwise not in accordance to the law. Where is your argument going with respect to those choices?
My argument is this. What we're talking about is a good faith argument. CCA must have known, right, that it was selling directly to the U.S. Marshal Service, therefore it acted in bad faith when it accepted that NTTC.
But the question is, in reviewing the hearing officer's decision,
Yes?
and giving him that deference that's required, okay, and reviewing the record as a whole, okay, where is CCA standing? Are they saying it was arbitrary, capricious, or not according to law, or is it not supported by substantial evidence?
Well, it's interesting you should raise that because in our answer brief, in CCA's answer brief, we talked about the standard review. We dropped a footnote and said, we really don't know what the standard review is on this issue of good faith because it wasn't an issue below. We don't know what standard of review applies because good faith was never raised. The department didn't allege that CCA acted dishonestly or with an intent to mislead, or that it even knew that that misstatement and that single email was wrong.
But the problem is, well, I don't want to say a problem. The Court of Appeals raised it because it found substantial evidence, as you're conceding to, and then just said almost de novo they were wrong on.
Yes.
They were wrong on the safe harbor.
I'm glad you, the hearing officer absolutely discussed the misstatement, but only in the context of CCA's estoppel argument. He did not talk about it in connection with the safe harbor. Below, CCA claimed that the department was stopped from changing its mind later and deciding that CCA was liable for the 7.9, or couldn't take the 7.947 deduction because it had earlier sent an email to CCA's agent saying you can take the deduction. But the hearing officer said, well, but before the department sent its email, CCA's agent had sent an email with a misstatement back in it, therefore no estoppel. That was his entire discussion of the misstatement. Yes.
Not necessarily. I'm looking at conclusions of law on page 27 of 29. Starts off, taxpayer has the burden to establish entitlement to the deduction. Deductions must be narrowly construed. The CIC and ISA predominantly involve performance of services pursuant to 793. Taxpayer did not meet his burden of establishing it was entitled to the deduction under 7947. Because no deduction or certificate covered the transaction at issue, taxpayer did not establish good faith acceptance of the NTTC and thus was not entitled to a safe harbor protection under NMSA 7943. I mean, that's right there in it.
But he said,
it might be inartfully drafted, but it is squarely before the hearing officer and therefore squarely before the Court of Appeals and in front of us.
but he didn't actually analyze good faith. He said because CCA didn't qualify for the 7.947 deduction, it also didn't qualify for the 7.943 good faith safe harbor. He didn't say,
Taxpayer did not establish good faith.
which part are you reading?
H. Taxpayer did not establish good faith acceptance.
Because it didn't qualify for 7.947. The only reason he gives for that conclusion is that CCA didn't qualify for the 7.947 deduction, and that's our entire beef with the hearing officer's legal ruling on the safe harbor. The hearing officer essentially said, if a taxpayer doesn't qualify for the underlying deduction, it also doesn't qualify for the safe harbor, meaning that only taxpayers that already qualify for a deduction.
I think
and
you're
don't-
reading that. I mean, I see what you're saying, but I don't read it H that way. I think it's saying because there was that statement made by CCA's agent, they were not entitled to the certificate, and because they did not accept it in good faith, they were not entitled to the protection.
Well, I can address that, sure. I'm looking at H. It says, because no deduction or certificate covered the transaction at issue.
Based on the G.
I
mean, it's, oh, okay, sorry.
Yeah, I'm just
H.
reading it. I'm just reading it straight out of the decision. Because no deduction or certificate covered the transaction at issue, taxpayer did not establish good faith acceptance of the NTTCs and thus wasn't entitled to the safe harbor protection. So what's the reason the hearing officer gives? Because no deduction or certificate covered the transaction at issue. He's saying there, because CCA didn't qualify for the deduction under 7.947, it didn't qualify for 7.943 safe harbor. But that means, if you think about it, only taxpayers that already qualify for an underlying deduction and thus don't need the protection of the safe harbor, because they already qualify for a deduction, can take the protection.
I don't agree with that portion of the argument in the briefing. Because it renders part of this kind of a nullity. So sure, you have somebody says at the time of acceptance, I qualify. That's what your argument. I qualify. I don't need safe harbor. But that isn't technically true, because what if you safe harbor is designed for I qualified and then the buyer does something different. Therefore, I am protected. I mean, that's what the safe harbor is about.
I think it's broader than that, Justice. I think the safe harbor protects taxpayers who accept an NTTC and later find out they don't qualify for, but maybe that's because the buyer was doing something at the time they accepted the NTTC that meant they didn't qualify. It doesn't have to.
You know, but you're arguing that if we follow the path that you're asserting in the hearing officer's conclusions of law, you're saying that just means if you qualified at the front end, only those who are qualified at the front end are entitled to safe harbor, but they don't need safe harbor because they've already qualified. That doesn't account for the evolution of time and a change in purpose by the buyer, and that's what the safe harbor is designed to protect.
I think it's designed to protect the front end and the back end.
And that's fine too, but you were saying it was limited in some fashion to only those who qualified at the front.
I didn't mean to imply it was front end or back end. All I said was at whatever point in time it's determined that the taxpayer doesn't qualify for the underlying deduction, if it accepted an NTTC in good faith, it doesn't matter. It can still avoid your receipts tax liability.
Okay, so then how is this not a McKinley ambulance case? Because the argument in McKinley could be very the same and say, when I took it, I thought it was a proper qualification, even though statute didn't allow for it, but it's in good faith. So I'm struggling now with distinguishing that from McKinley ambulance.
I'm glad you asked me that, Justice, because it allows me to tell the one joke
Right.
that I brought with me today. So last night I was dining out and I actually heard the following question from a nearby table. What's the difference between a flat enchilada and a rolled enchilada? And the difference between McKinley and the answer is it's large and obvious, right? And I think that's true of the difference between McKinley ambulance in this case. In McKinley ambulance, as Mr. Middle summarized, the taxpayer was providing both in-state ambulance services and out-of-state ambulance services. And it was given an NTTC by its buyer that only covered out-of-state ambulance services. And in fact, there was, and that deduction actually existed under Mexico law. It didn't cover in-state ambulance services, and no deduction existed for those services under New Mexico law. But the taxpayer nonetheless used the NTTC and said, we want to take a deduction for in-state ambulance services.
Okay, but you're missing one step. Did the taxpayer say, I took it in good faith. I thought it covered what I'm using it for?
Well, I don't think
we did.
they didn't even get there. The Court of Appeals didn't even get there because it said the NTTC you accepted doesn't even cover, on its face, it does not cover the deduction.
And that's what the hearing officer said. No.
No, the NTTC in this case covered the deduction. I mean, 7947, it's right there in the NTTC. And that is
solely
deduction.
because of the statement made by CCA's agent.
Well, we're talking just about what does the face of the NTTC say. On its face, the NTTC and McKinley ambulance did not cover in-state ambulance services. It could never, under any state of facts, proven qualify for that deduction based on the NTTC because the NTTC on its face didn't apply to those kinds of receipts. That's not true here. Now, not qualifying for a deduction that's covered by an NTTC is different from an NTTC just not covering the deduction at all under any
for the
state of facts.
deduction if you contract directly with the feds. Do you?
What's that? I'm sorry?
If CCA contracts directly to the feds to house federal prisoners, do they qualify for the deduction?
It was our contention that yes, and bearing in mind that there was no contract between CCA and the U.S. Marshal Service, and CCA was accepting payments as a payment agent. At least that was the evidence CCA presented.
Fair enough.
So, but McKinley and the same problems exist with a couple of other decisions that the hearing officer relied on in that safe harbor discussion. One was the gas company case, gas company versus Ocheski. And the other one was an administrative decision called In Re Adeco. Now, in Adeco, a temp services company was selling temporary staffing services to the city of Albuquerque, services. And it accepted an NTTC from the city that covered sale of goods to the city. But the taxpayer nonetheless sought to take a deduction for its sale of services to the city. And the hearing officer in that case said, the NTTC on its face doesn't cover the sale of services to the city. Under no state of facts can you qualify for good faith acceptance of the NTTC, because on its face it doesn't apply. And also, by the way, there is no deduction under New Mexico law for the sale of services to the city. And the same with problem with gas company. The taxpayer's NTTC just didn't apply on its face to the exemption that the taxpayer was seeking. So that's how those decisions are very different from this case.
Getting back to Chief Justice Bacon's questions about good faith, in your argument, a finding of no good faith is a finding of no good faith. Wouldn't make any difference whether it's under 47 or 43. I mean, there's lack of good faith is lack of good faith, no matter what statute you're talking about. Or is it lack of good faith under 47 mean one thing, and lack of good faith under 43 mean a different thing?
Well, let me start here. There is no definition of good faith for these purposes in the Gross Use Tax Act. So the department has suggested.
Except in good faith that the buyer or leasee will employ the property or service transferred in a non-taxable manner. That's to the extent that it's defined.
Right, but that phrase good faith, it's not defined. This department has suggested a definition which I think is fine. It means lack of dishonesty or lack of intent to mislead. There's nothing in the record that CCA acted dishonestly or the intent to mislead. But to get to your question, CCA obviously knew how it was being paid by the U.S. Marshal Service. How can I dispute that? It's a big leap from there to CCA acted in bad faith.
Well, it's whether they acted in good faith, you're kind of.
Or whether they acted without good faith.
Well, it says that you must accept it in good faith. It doesn't say anything about bad faith or lack of this, it just says you accept it in good faith as to these facts.
Okay, well, let me address that. There's this issue that's been floating around in the background. And actually it's not floating around in the background, we talked about it at the top of my argument. What about this burden that this taxpayer supposedly has to prove good faith? Well, the whole point of an NTTC is to allow a taxpayer to rely on it, right?
That's under the 18 amendment. But under the 17, it says that qualifiers.
But Counsel, I agree with that, but in this situation, CCA actually went on behalf of the county to get the certificate.
Mhm.
Okay, so they're relying on their own presentation to get the certificate.
Understood, but again, I go back to knowing that you're being paid directly by the U.S. Marshal Service is not the same as knowing that you don't qualify for the deduction. Because again, CCA's belief was it was being paid as billing agent, as collection agent
But
for the
they're
county.
the person who made the representation. I'm assuming Ryan LLC was hired to
Yes.
do just this, to
Yes.
get them the tax deduction. This
Yes.
isn't, it's far-fetched to believe that this person who's qualified as an accountant or a business person or a tax person trying to benefit the taxpayer is now claiming they didn't know simply because
Well, I'm not claiming one way or the other. All I'm saying is there's nothing in the record to suggest that Ryan, let alone CCA, knew that that statement was false. And let me talk about
Well, Counsel,
proof. Go ahead. I'm
but
sorry,
that
Justice.
statement was made nonetheless, right?
I'm sorry, excuse me?
That statement was made nonetheless on the record.
It was absolutely made in an email, and it was false. The question is, Did Brian know it was false? There's nothing in the record to support that it did.
So-
But the record
That law
nonetheless
CCA.
has that statement in it.
What's that?
Nonetheless, that statement is part of the record.
That's correct. And by the way, there's no evidence in the record, no support in the record that the department actually relied on the statement. That's a complete side issue, but just to point that out, throughout his decision, the hearing officer says, I'm presuming that the department relied on it. But be that as it may,
Help me, remind me again, I apologize. Where is the requirement that it be a knowing false statement in order to defeat, let me get the burden right. So you're claiming was it done in good faith? Where, or to defeat that, where is the requirement that it be a knowing false statement?
we don't know what good faith means for these purposes, Your Honor. Now,
Where would I
the
look?
cases generally say, you can, and this is what the Court of Appeals below in this case said, you can base your good faith on the NTTC. Okay? The whole point of the NTTC is to allow taxpayers to rely on it. If you put a burden on taxpayers to establish good faith based on some other fact, then they have to monitor their buyers. If they have to prove that they in good faith believed that their buyers would make a non-taxable use of the goods and services based on something other than the NTTC, they have to monitor their buyers.
So there's no obligation by your client other than to not make a knowing material misrepresentation. Otherwise, everything that you get from tax and rev you can rely on.
Essentially. I mean, obviously, if a taxpayer knows something, well, in fact, let's talk about the Connell Lynn case, okay? In that case, a general contractor was buying materials to build a hotel from its subcontractors and was giving them NTTCs. Now, there was a provision in the contract between the contractor and the subcontractors saying to the subcontractors, you're going to have to be liable for gross receipts tax. So it was argued in that case, well, that provision of the contract put the taxpayers, the subcontractors, on notice that they would be liable for gross receipts tax. And the court said no. They were given NTTCs. That's a representation by the buyer that they don't have to pay gross receipts tax, that the buyer's going to make a non-taxable use of this goods and services sold. So I think it's important, it's really important to draw a distinction between CCA knowing that how it's being paid by U.S. Marshal Service, because obviously it did,
Mhm.
and CCA acting without good faith, or CCA not having a good faith belief that this was a sale of a license for resale.
Counsel, you keep overlooking the fact that the statute in question says it defines its good faith. And good faith that the buyer or leasee will employ this property or service transferred in a non-taxable manner.
And
That's
CCA,
the definition of good faith used in the statute. The
Well,
18th statute doesn't have a definition, nor does 7-9-47. It just says NTTC.
right, I mean, the phrase good faith modifies the rest of the sentence, and we don't know how it modifies the rest of
But
the
we
sentence.
do know the regulation, and so even, yeah, there's the time of the transaction, but the regulation goes on to say the taxpayer claiming the protection of a certificate continues to be responsible that the service is performed thereafter of the type covered by the certificate.
The only response I have to that is there are multiple Court of Appeals decisions that say if you task taxpayers with monitoring their buyers to make sure they continue using the goods and services in a non-taxable manner, that creates a tremendous burden and it eviscerates the system.
But they were still getting the invoices presumably.
And once again, CCA believed it was being paid by Torrance County through as a payment agent. Like it was receiving Torrance County's payments from the U.S. Marshal Service as agent for Torrance County. And again, there was a contract in the record that was between Torrance County and U.S. Marshal Service, not CCA. And again, I'm not saying that CCA should have gotten the 7947 deduction. I'm saying that indicates that CCA didn't act in bad faith. It just ended up not convincing the hearing officer.
Which we defer to factually.
Well, again, there was no finding of bad faith.
Well, except on page 24 of 29, the hearing officer wrote, to the extent taxpayer purports to rely in good faith on Ms. Abo's email, such reliance is also unreasonable. The facts that Ms. Abo relied upon were undeniably and undisputably incorrect. And prior to that, he talks about good faith. Is it as clear as perhaps we'd like it? Maybe not, but I think he addressed it in the decision and order.
But not in the safe harbor discussion. That's all in the estoppel discussion.
Okay.
He's saying you can't claim estoppel when you misinform the department. Fair enough, but that's not what he based his safe harbor ruling on. He based his safe harbor ruling purely on legal grounds, which don't make any sense. Am I over? I'm over.
Yeah.
Way over. I'm sorry, I apologize.
That's okay.
Well, thank you for this opportunity.
Thank you.
Thank you.
I'd like to start with the agency, that CCA is just acting as the agent for Torrance County, and the bypass. And that supposedly was pursuant to a contract. The contract that the Court of Appeals called a purported contract. That's in paragraph 3. Now this contract, two things would happen. One, it was not produced in 2012 at the time they asked for the NTTC. Wasn't produced in 2016 when they were audited. Wasn't produced in 2018 at the time of the hearing. It is a purported contract. But even if there is a contract, which the hearing officer called no evidence, didn't see no evidence, said the evidence was minimal and unpersuasive, that transaction falls under a different section of the tax code. That falls under 793.5 as an agency question.
You're just saying to the court, this purported contract is not in the record.
It's not in the record. David Garfinkel testified to it at 1 hour and 52 minutes of the transcript to 1 hour and 54 minutes. The Court of Appeals found it was a purported contract and made allegations that the department should have produced it. He never got it. The second thing that I was saying about the disclosed agency, that's under 793.5. Ryan Group is a very sophisticated tax person, agency. They would not have gotten the deduction under 793.5. They would have gotten a deduction for that amount that was reimbursable. It's a totally entire different transaction that was not raised at the hearing, but it's been raised here. It's this agency. It's false. And so, Chief Justice, it does matter that the payments have to flow a certain way. Absolutely. It makes all the difference in the world that the payments were coming from the marshal to CCA. And it's all the difference from the marshal to Torrance to CCA, because that's a disclosed agency relationship. You look at it under a different section of the tax code. If you want.
Talk to us about paragraph H.
Okay, but I will. But what's also, and I apologize for this because I have the Westlaw version, and it's star 16. What the hearing officer found, there is no evidence that taxpayer made an informed judgment or determination based on reasonable grounds that gross receipts tax did not apply to the services subject of this protest. He made a finding of no inquiry. So yes, the language in H could be clearer, but
Where's the language about no inquiry?
it's star 16. That's
I don't
why
know
I'm
what that
apologizing.
is, so.
Yeah,
Star
I'm sorry.
16.
If somebody has the Westlaw version.
Okay, go ahead.
Okay, so yes, the language could have been clearer, but let's back up a little bit further. The burden is always on the taxpayer, always. Sometimes it can switch in the Casillas case and the MPC case, but it's always on the taxpayer. Once it was raised at the hearing, it was incumbent on CCA to establish that they had accepted in good faith. It's not up to the department to show their lack of good faith or bad faith in the acceptance. And it's council keeps focusing on the intent to deceive. But the definition that was used by the Court of Appeals in Erica versus Mexico Regulation License was straight out of Black's Law Dictionary, which this court uses. And it says an honesty in purpose or belief. So instead of focusing so much on the intent to defraud, we can just say they had no honesty in purpose. They had no honesty in belief because the transaction, the money was flowing. And as I said, it makes all the difference in the world to us
So
state tax
I
attorneys.
wanted to go back, this is more of a clarification of the record. You said there was no contract in the record between CCA and Torrance, or between Torrance and the United States military?
No, those two are in the record. And the contract that's not in the record is, David Garfinkel testified at the hearing that he had a separate contract that the county authorized CCA to be their agent with the marshals
For purposes of payment.
for purposes of
Got
payment.
it, okay, thank you.
And that's not in the contract. But the contract that is between CCA and Torrance County at paragraph 3 says that the billings will go from CCA to Torrance, and Torrance will pay. And then in section 13, it says there'll be no amendments to this contract unless they're in writing. We have no evidence of any writing. So the burden is and then I'd like to clean up Continental Inn. That's not really, the way I read Continental Inn, Continental was a contractor. Building a building employs a bunch of subcontractors. Gives the subcontractors NTTCs, also gives them a contract that says, you're gonna pay my tax. Okay, what the court found first was the paying of the tax, the contract that obligated the subcontractors to pay the tax was void as against public policy, that every taxpayer is responsible for their own taxes. Once that contract is out of the equation, the subcontractor did accept in good faith. They knew that it was a construction project. They were doing the work. I mean, that's enough of an inquiry to raise the level of good faith. So that's how I read Continental Inn. And so in closing, this all matters because we are talking about the public's money here. These are monies that run the state. We're not punishing CCA. We're not allowing them a deduction that they don't deserve. In fact, there were 4 years of audit. 2 years are not before you because they got the deduction and it was outside the statute of limitations. But what the core of this is, we're now inviting clever consultants to come in and to try to lobby the department without consequence to their actions. They can just plead that they didn't know. Principal pleads they didn't know. And it's unfair, not to the department, not to the state government. It's unfair to the citizens of the state. I mean, this is money that pays our salaries, builds our roads, builds our schools. And so the onus should clearly be on CCA. They knew they made material misrepresentations through their agent, and they shouldn't be allowed to talk. And with that, I thank you for your time.
All right.
Thank you.
Thank you, counsel, for your argument today and for the briefing. The court will take this matter under advisement and return a decision as soon as time permits. Thank you.
Attend the court, please.